Something very strange is happening in one of the most talked about legal battles in America right now. The lawsuit between author Michael Wolff and First Lady Melania Trump, a case that exploded onto the scene with enormous energy, enormous stakes, and enormous public interest, has gone almost completely quiet, and that silence, more than any court filing or press statement, is telling us everything we need to know about the strategy being deployed from Melania Trump's side of this fight. Because when powerful people go quiet in legal battles, it is rarely because they are confident. It is almost always because they are buying time. And time, as we are going to break down today, is the one thing that Melania Trump desperately needs, and the one thing that Michael Wolff is absolutely refusing to give her. Let us go back to the beginning, because context matters enormously here. In October of 2025, Michael Wolff, the journalist and author famous for his explosive inside accounts of the Trump White House, found himself on the receiving end of a legal threat unlike almost anything seen in recent American media history. Melania Trump's attorneys sent him a formal demand letter threatening to sue him for over $1 billion in damages. $1 billion. Not for defamation in the traditional sense, not because he published a book, not because he ran a news article, but because of statements he made publicly linking Melania Trump to Jeffrey Epstein, the disgraced financier and sex trafficker who died in a federal jail cell in 2019. Wolff had claimed, drawing on his own extensive reporting and interviews, that Epstein had told him that he had introduced Melania to Donald Trump. That single claim, and others surrounding it, was enough to bring down the full weight of Melania Trump's legal machine on his doorstep. But here is where the story takes a turn that nobody on Melania's side appears to have fully thought through. Rather than backing down, rather than retracting, rather than doing what powerful people with billion-dollar threats expect their targets to do, Michael Wolff did the opposite. He sued her first. On October 22, 2025, before Melania's team could even organize their legal offensive, Wolff filed a lawsuit against the First Lady of the United States in New York Supreme Court, invoking New York's anti-SLAPP statute, a law specifically designed to protect journalists and speakers from exactly this kind of weaponized legal intimidation. Strategic lawsuit against public participation. The very name of the law tells you what Wolff believed Melania was doing, using the threat of ruinous litigation not to seek justice, but to silence him, to make him go away, to make all of this go away. And from the moment that lawsuit was filed, Melania Trump's entire approach to this case has been one long, carefully constructed exercise in avoidance. Let us be very direct about what has happened in this case since it began, because the timeline is damning when you lay it out plainly. Wolff files in October 2025. For more than 10 weeks after that, according to Wolff himself writing on his Substack, Melania's side does essentially nothing. 10 weeks. In a lawsuit where a journalist has publicly accused the First Lady of attempting to use a billion-dollar legal threat to suppress speech, her team's initial response is silence. Wolff described it himself as her either ignoring the suit or hoping it would simply go away. Think about that. The most powerful family in the United States, with access to the finest legal minds in the country, with the resources of a billionaire administration behind them, and their initial play is to pretend the lawsuit does not exist. That tells you something. That tells you they were not prepared for Wolff to fight back. That tells you the billion-dollar threat was designed as a blunt instrument of intimidation, not as the opening move in a genuine legal strategy. Then, in the final quiet week of December 2025, they finally moved. And the move they made is extraordinarily revealing. Rather than filing a substantive response to the lawsuit, rather than contesting the facts, rather than presenting any kind of defense on the merits, Melania's lawyers asked a federal court to take jurisdiction of the suit away from the New York State court where Wolff had filed it. Michael Wolff himself, in his own words on Substack in early January 2026, called this exactly what it was. He described it as, in his phrasing, a signature Trump delaying tactic. Not his words being put in his mouth, his direct public characterization of what Melania's legal team was doing. They were not fighting. They were moving the furniture around to buy themselves more time. They were trying to shift the battlefield from New York, where anti-SLAPP protections are among the strongest in the entire country, to federal court, and potentially to Florida, where Melania's lawyers are based, and where the legal landscape would be considerably more favorable to her side. Why does the jurisdiction matter so much? Because New York's anti-SLAPP law is a remarkably powerful instrument in the hands of someone like Wolff. If Wolff wins on the anti-SLAPP claim in New York, Melania does not just lose the case, she potentially has to pay Wolff's legal fees, and the entire machinery of her attempted intimidation is exposed and punished by the court. That is why her team fought so hard to get out of New York. That is why they argued that she was not properly served, because papers were handed to a doorman at Trump Tower, which they claimed was not her residence. That is why they pushed for federal court in Florida, the home of Judge Aileen Cannon, who was notably favorable to Donald Trump in his federal criminal case, and whose sources close to the White House have reportedly jokingly referred to as a future Supreme Court justice. The venue shopping here is not subtle, it is brazen, and it is being done in plain sight, which suggests that Melania's legal team either does not care that we can see what they are doing, or they believe that the procedural machinery of delay is powerful enough that the optics do not matter. But let us talk about the serving problem, because this is one of the most extraordinary legal loopholes that has emerged from this case, and it is one that Wolff has publicly and repeatedly called out with visible frustration. In his own words, the difficulty of serving Melania Trump is almost absurd. She is the First Lady of the United States. She is protected at all times by the Secret Service, one of the most highly trained and experienced security forces on the planet. You cannot approach her on the street, you cannot serve her at the White House, you cannot get anywhere near her through normal legal channels. Wolff's team tried to serve her attorney, Alejandro Brito, in Florida. That effort also ran into obstacles, and so you end up in this bizarre legal loop. Melania's team argues she has not been properly served, but the reason she cannot be properly served is precisely because she occupies a position that makes conventional service of process essentially impossible. And then, to compound this loop further, when Wolff's team asked the New York court to acknowledge their service efforts and deem her served through alternative means, Melania's team immediately moved to shift the case to federal court, which had the effect of freezing that very question in place. The federal venue change stays any decision on service, which means she can continue to maintain in federal court that she has not been served. She has not been served because she cannot be served, and she is now in federal court arguing she cannot be dismissed on service grounds while simultaneously benefiting from the fact that the service question was never resolved in state court. It is a legal maze constructed entirely out of procedural maneuvers, and it has one purpose: delay. Now, her appointment, and what her position as First Lady means for this case, deserves serious scrutiny, because it has been used as a shield in ways that should trouble anyone who believes in press freedom and the rule of law. Melania Trump is not an elected official. She did not run for office. She did not appear on any ballot. She holds the position of First Lady by virtue of her marriage to the President of the United States, a position that comes with enormous privilege, enormous protection, and now, it appears, enormous legal insulation. The argument being deployed by her legal team is essentially that her status as First Lady makes her uniquely difficult to serve, uniquely difficult to subject to normal court process, and uniquely qualified to demand that any litigation against her be conducted in forums of her choosing. This is a deeply uncomfortable precedent. If the First Lady can use her position to effectively make herself unreachable through conventional legal process, what does that say about accountability? What does it say about the principle that no one, not even the most powerful people in the country, is above the legal obligations that apply to everyone else? Wolff has made clear that he finds this dynamic outrageous, and frankly, it is hard to argue with him. And speaking of Wolff, let us talk about who this man is, and why Melania's legal team may have made a catastrophic miscalculation in choosing him as a target. Michael Wolff is not a blogger. He is not a podcaster operating out of his spare bedroom. He is the author of Fire and Fury, the book that gave the world its first devastating inside look at the chaos of the early Trump White House. He is the author of 3 subsequent books about Donald Trump, each one drawing on access and reporting that no other journalist had managed to achieve. And crucially, critically for the purposes of this lawsuit, Michael Wolff had extensive contact with Jeffrey Epstein. He interviewed Epstein multiple times. He was embedded in the same social and professional world that Epstein inhabited. He knows that world, he reported on that world, and he has been publicly and completely clear that he stands entirely by the statements he made about Melania Trump and her connections to that world. He has not wavered, he has not qualified, he has not softened. When Melania's team sent him that billion-dollar demand letter, they presumably expected him to do what most people would do when faced with the threat of financial annihilation: fold. He did not fold. He filed a lawsuit the same week. He went on Instagram and told the world that rather than being silenced, he would actually love nothing more than to get Donald Trump and Melania Trump under oath in front of a court reporter to discuss everything they know about their relationship with Jeffrey Epstein. That is not the statement of a man who is intimidated. That is the statement of a man who believes he has the facts on his side and intends to use every legal tool available to him to establish that. And Wolff did something else that Melania's team almost certainly did not anticipate. He turned this lawsuit into a public cause. He launched a GoFundMe campaign to fund his legal battle against a woman whose husband is one of the wealthiest people in the country and who has access to legal resources that most individuals could not dream of. That campaign raised $750,000, $800,000, from over 15,000 individual donors. People who have, in Wolff's own characterization, had enough. People who looked at a situation where a sitting First Lady's lawyers threatened a journalist with a billion-dollar lawsuit to stop him from reporting and decided that this was worth fighting. That fundraising success did two things simultaneously. It gave Wolff the financial firepower to sustain a prolonged legal battle, and it sent an unmistakable signal to Melania's team that public opinion was not on their side. Melania's lawyers actually tried to use this fundraising against Wolff in their legal filings, arguing that because he was raising money, this proved he was not a serious litigant, that the whole lawsuit was a publicity stunt. This argument is so weak it is almost embarrassing. Raising money to fight someone with unlimited resources is evidence of determination, not dishonesty. But the fact that her team deployed this argument tells you something important. They are not winning on the facts, so they are grasping for procedural and rhetorical tools wherever they can find them. What Wolff wants from this lawsuit, and what he has stated publicly and repeatedly, is deposition. He wants discovery. He wants subpoena power. He wants Donald Trump and Melania Trump sitting across from a court reporter, under oath, answering questions about Jeffrey Epstein. And this is why Melania's team is so desperate to get this case dismissed, transferred, delayed, or moved to any forum other than a New York court with a fully operational anti-SLAPP mechanism. Because if this case proceeds to discovery in New York, if Wolff gets his subpoenas, the questions that get asked will not just be uncomfortable. They will be on the record. They will be under oath. And they will be asked by a man who spent years reporting on Epstein's world, who interviewed Epstein directly, and who believes with complete conviction that there is a story to be told about the Trumps' relationship with that world that has never been fully told. Melania's legal team is not afraid of losing this lawsuit. They are afraid of what the process of litigating it will reveal. Now let us talk about what happened on April 9, 2026, a day that may go down as one of the most strategically bizarre decisions made by anyone connected to this administration in recent memory. On that day, Melania Trump stepped in front of cameras at the White House and made a rare public statement. She publicly denied any ties to Jeffrey Epstein. She said she first met Epstein at an event she attended with Trump in the year 2000. She offered her version of events, unsolicited, unrequested by any court, completely voluntary. And the response was not what her team was hoping for. The timing of this statement was immediately scrutinized by everyone following the case. It came one day after former Attorney General Pam Bondi had defied a congressional subpoena related to the Justice Department's handling of the Epstein files. It came just days after Trump had fired Bondi. The Epstein story was back in the news in the most explosive possible way, and Melania chose this moment to make a public statement. Why now? Nobody from her team provided a clear answer. There was no specific triggering event she pointed to. There was no new court filing that required a public response. The statement appeared to be an attempt to shape the public narrative around this case at a moment when the Epstein topic was consuming the national news cycle, but the effect was precisely the opposite of what was intended. Rather than quieting the story, Melania's statement reignited it with extraordinary force. Every news organization that had been watching this case quietly suddenly had a headline. Every commentator who had been following the lawsuit had a new hook. And critically, the statement did nothing to resolve the legal questions at the heart of Wolff's lawsuit. In fact, legal observers noted that by making a public statement on the very subject matter of the ongoing litigation, Melania had potentially complicated her own legal position. When you are trying to get a case dismissed on procedural grounds, arguing improper service, arguing wrong jurisdiction, arguing that the plaintiff has no legitimate claim, making a dramatic public appearance to address the substance of the allegations is a deeply mixed message. It suggests awareness of the case's implications, it suggests concern about public perception, and it gave Wolff's team fresh material to work with. Wolff himself has remained completely unmoved by any of this. Through every procedural maneuver, through every delay tactic, through the jurisdiction fight, through the service dispute, through the public statement, Michael Wolff has maintained the same position he took on the day he filed his lawsuit. He stands by his reporting. He believes what he has written and said. He wants his day in court. And as of the most recent public information available, the case sits in front of Judge Weiskachil in federal court, with both Melania's motion to dismiss and Wolff's motion to remand the case back to New York State Court, fully briefed and awaiting a ruling. The last known court filing was February 27, 2026. The judge has not ruled. The case is in that peculiar legal limbo that powerful defendants love and persistent plaintiffs endure. But here is the thing about limbo in cases like this. It does not last forever. Judges rule eventually. Motions get decided. Cases either proceed or they do not. And if this case proceeds, if Wolff wins his motion to remand back to New York State Court, if the anti-SLAPP mechanism stays in place, then everything Melania's team has been trying to avoid becomes possible. The depositions, the subpoenas, the questions under oath, all of it becomes possible. And Wolff has made absolutely clear that he will pursue every single one of those tools with everything he has. The delay in this case is not a sign of strength from Melania's side. It is a sign that she is trapped. Trapped not by a technicality, not by a legal error her team made, but trapped by the fundamental reality of who Michael Wolff is and what he knows. He interviewed Epstein. He is embedded in that world. He has sources and reporting that stretch back years. He cannot be dismissed as a gossip or a fraud. His track record of accountability journalism on the Trump orbit has been demonstrated again and again, and he is not going away. He has made that as clear as anyone can make anything. The billion-dollar threat that was supposed to end this story did not end it. It started something that Melania Trump and her legal team are now struggling to contain, and every delay, every procedural maneuver, every jurisdiction fight, every silent week where the court docket shows no new filings is simply another chapter in a story that Michael Wolff appears entirely prepared to see through to its conclusion. The questions this case raises go far beyond any one lawsuit. They go to the heart of what press freedom means when the most powerful people in the country can deploy billion-dollar threats against individual journalists. They go to the heart of what legal accountability looks like when the First Lady can use her position as a shield against normal court process. They go to the heart of what the public has a right to know about the people who hold the highest offices in the land and their connections to one of the most disturbing criminal enterprises in modern American history. Michael Wolff did not start this fight. He was threatened into it. But he has made unmistakably clear that having been forced into it, he intends to fight it completely, transparently, and without retreat. And that, perhaps more than any court filing, more than any press conference, more than any jurisdiction argument, is what should be keeping Melania Trump's legal team up at night.